Okay, so we were dealing with Article 110 of the founding treaty, providing for other products. As far as this provision is concerned, for a tax caught by the prohibition on discrimination, the most important question is whether there is a protection on the domestic products which would be detriment to the imported products. Therefore, the main question is whether these products can be substituted by each other. Because as you would remember, the paragraph does not provide similar products, but other products. Therefore, to be able to speak about a discriminatory taxation as regards the second paragraph, then we have to find out whether these products concerned, the imported products and the domestic products, can substitute each other. And there are two different tests applied by the Court of Justice to find out the answer of this question, to find out whether the goods are in competition. The first test is the economic test. The court applies or considers whether if the price of a product goes up, sales of other product increases. Therefore, the question is for the Court of Justice to find out whether the price of one product increases, sale of other product increases. So if there is substitutability, then the products are in competition. In the second test, like the test, it applies as regards similarity under Article 110, paragraph 1. The court takes into account the factors such as the manufacture, the composition of the product, and the consumer preference, both present and future. Later. In the case 170/78, Commission versus United Kingdom, the question was whether beer and wine, table wine, light table wine, are in competition. At that time, the UK government taxed the wine approximately 5 times more than beer. Beer was domestic product and wine was imported product. The court held that the UK government gave an indirect protection to beer and breached Article 110, paragraph 2. According to the court, 2 drinks were included in the same category of alcoholic beverages. They were both product of natural fermentation and could be used for the same purpose. They were consumed, they could have been consumed and in the same way as well, either as refreshments or with meals. Therefore, it was decided that they were in competition between, and 110 paragraph 2 applied. I'll take the questions afterwards, all right? The third aspect, third component of free movement of goods or customs union, as you know, is non-tariff barriers. Prohibition of non-tariff barriers. Non-tariff barriers are also called as, sorry? Yes, non-fiscal barriers, and they include prohibition of quantity restrictions and measures having equivalent effect. There are three provisions to be applied here depending on the circumstances of the Treaty on the Functioning of the European Union. Article 34 applies for quantity restrictions and measures having equivalent effect for imports. Article 35 provides for quantity restrictions and measures having equivalent effect for exports. And Article 36 provides for derogations, exceptions, where these prohibitions do not apply. It is provided under Article 36. But as you will be seeing now and as you will be reading, you will be seeing that the major problem or case law is based on or has arisen under Article 34 and 36. There is little case law on Article 35 when you compare it with Article 34. Now, as far as Article 34 is concerned, meaning prohibition of quantity restrictions and measures having equivalent effect for imports, we deal with the article, or we can deal with the article under two different headings. First, what it restricts, prohibits is quantity restrictions. And second, measures having equivalent effect. Then the first question is, what is a quantity restriction? What is a quantity restriction? Yes?
We can give example of quotas and embargoes.
Exactly. Quantity, there is no problem today about quantity restrictions themselves. There are quotas and bans, limitations on the amount of the goods that are subject to import. They are prohibited by Article 34. Which provides that quantity restrictions on imports and all measures having equivalent effect shall be prohibited between member states. They are prohibited, therefore, by Article 34, and according to the case law of the Court of Justice, they can only be justified, such limitations can only be justified, can only be saved by Article 36 derogations and principle, according to principle of proportionality. The main problem is about the measures having equivalent effect. These cover a wide range of issues, wide range of measures, such as national rules on the shape, content, packaging, and labeling of goods. Which may hinder internal trade, but cannot be described as quantitative measures. What would measure mean here? In Turkish, what would that mean here? Tedbir, önlem, düzenleme. According to the case law of the European Court of Justice, legally binding acts or practices which are capable of influencing the conduct of the consumers and traders, as well as administrative practices, may be called as measures, or they are included in the term measures. You will read an important number of cases about measures, how it is interpreted by the Court of Justice. Then, what are the measures having equivalent effect? You will have presentations on the free movement of goods, some of you, and most of these presentations is about this topic, measures having equivalent effect. What is a measure having equivalent effect? A general definition is found in the very famous decision of D'Assonville of 1974. The European Court of Justice gave a very general definition of measures having equivalent effect in this decision. According to the court, all trading rules enacted by the member states which are capable of hindering directly or indirectly actually or potentially intra-community trade are considered as measures having equivalent effect. All trading rules enacted by the member states which are capable of directly or indirectly, actually or potentially hinder intra-community trade are considered as measures having equivalent effect. Therefore, this is such a large definition, a wide definition of the term, and includes any measure that hinders or even potentially hinders the imports and exports in any way. It may be intended by a member state or it may not be intended by the member state. Any act, therefore, limiting the trade between the member state as such could be coded by the D'Assonville formula and therefore would that member state would be in breach of Article 34 according to the Court of Justice. There are interesting cases about the measures having equivalent effect in the case law of the Court of Justice. For example, national promotional campaigns. National promotional campaigns. Like bi-national, like bi-Irish, in a case, for example, of 18-1, Commission versus Ireland, the ECJ held that the activities of a company which was controlled by the government for the promotion of sale of national products by advertising such products and the use of homemade sign on the goods infringed Article 34. The company had advertisement campaigns on the use of home-produced goods, home-produced products. There was a symbol on the goods as well. And this advertising campaign of that company was backed by the Irish government. Therefore, the court said here the campaign, although it was not a quantity restriction itself, in effect, it made domestic products, or it tried to make domestic products more on the eyes of the consumer, better products, and campaign was for that. Therefore, the Court of Justice provided that this is an infringement of Article 34. Another example is discriminatory national marketing rules. The national markets, the national marketing rules, may also provide for certain restrictions on imported products, which may infringe Article 34. For example, import licenses, which by their nature only apply on imported goods, import licenses, or the requirements to stamp the origin of the goods on the product itself. Or, for example, in a case of 81, the Court of Justice provided that the Belgian rule requiring the margarine to be produced in cubes and not in any form, any other form, would breach Article 34 because it imposed an economic disadvantage on exporters to Belgium. There was a requirement to cut the margarines, to produce the margarines in cubes and not, for example, in rectangular shapes. Therefore, the Court of Justice said this is a disadvantageous situation for the exporters to Belgium. Or, for example, the price restrictions involving maximum and minimum pricing is also considered as a measure having equivalent effect. The member states may only, or the national rules, which restrict the import of the goods under Article 34, may only be saved by Article 36 derogations and according to the principle of proportionality. Article 36, therefore, provides for general prohibition. Sorry, Article 36 provides for exceptions for general prohibition of Article 34. Under the first sentence of Article 36, there is a list of derogations. This list is a closed list, therefore cannot be enlarged. And according to the second sentence of Article 36, these limitations shall not constitute a means of arbitrary discrimination or a disguised restriction on trade between member states. Therefore, these exceptions is subject to the limitations as provided under the second sentence of Article 36. The list includes different exceptions. I will not go into detail. There is a good number of cases of the European Court of Justice. Please, you are responsible from this case law. Otherwise, there is no possibility that we finish all the topics in class, like public morality, public security, public health, protection of life of humans, protection of life of animals, artistic, historic, or archaeological heritage, and the protection of industrial and commercial property. As long as these exceptions exist in compliance with the second sentence of Article 36, then they can be accepted as exceptions of Article 34 and save the member states concerned. Article 34, as far as the measures having equivalent effect are concerned, Article 34 do not only prohibit distinctly applicable measures, when we say distinctly applicable measures, we mean the restrictions or the national rules which restrict the free movement free movement of goods or importation and exportation of goods by providing restrictions on the imported or exported products. Therefore, in the distinctly applicable measures, these measures apply to imports and exports only, distinctly, because of the fact that they are imported or exported. When we say indistinctly applicable measures or equally applicable measures, we mean the measures that apply both to domestic and foreign products. Equally applicable measures or indistinctly applicable measures apply equally to foreign products and domestic products, whereas distinctly applicable measures only apply to imports or exports. Therefore, Article 34 does not only include distinctly applicable measures. Article 34 does not only prohibit distinctly applicable measures. It also covers the national rules which apply or which on the face of it make no distinction between domestic and foreign products. Since the Dasonville formula is very large, there is a possibility that distinctly and indistinctly applicable measures are covered by Article 34. Therefore, a gateway was provided, an escape possibility was provided by the Court of Justice in another very famous case of 1978, Cassis de Dijon. The Court of Justice in Cassis shall limit the indistinctly applicable measures. Some of the indistinctly applicable measures shall not be covered by Article 34. In Cassis, the case concerned a prohibition on the marketing in Germany of certain spirits with less than 25% alcohol. Which included cassis, a blackcurrant alcoholic liqueur, having 15 to 20% alcohol. The ban applied to both domestic and imported products, regardless of their origin, and did not distinguish between national and foreign drinks. Therefore, was it distinctly applicable or indistinctly applicable? That was indistinctly applicable. The arguments made by German government for the ban was that the drinks having lower alcohol percentage would lead to alcohol tolerance. Therefore, they would lead to important health problems in the future. However, the actual result was that the ban had a negative effect on French imports, because that kind of alcohol was an imported product from France. Therefore, under Article 34, according to Cassis, or the Cassis judgment makes it clear that Article 34 also covers indirect discrimination. Therefore, even a national rule which applies both to foreign and domestic products may infringe Article 34. And the court has underlined this fact in Cassis, that as a principle, such measures shall breach Article 34, prima facie. Prima facie? Exactly. However, if the host states national rules can be justified according to one of the mandatory requirements, then there is no breach of Article 34, and the national interests takes precedence over free movement of goods. In Cassis, therefore, for the indistinctly applicable measures the Court of Justice used a confusing phrase as mandatory requirements to supplement Article 36 derogations. Let's put it like this. We have quantity restrictions and measures having equivalent effect. If there is a quantity restriction, such as a ban or a quota applied by a member state for the products of another, then there is a breach of Article 34. That national rule may still be saved under Article 36 derogations, exceptions, and according to the principle of proportionality. Okay? When there is a measure having equivalent effect, according to the Dassonville formula, this measure may be distinctly applicable, meaning a national measure applied, imports and exports, or it may be indistinctly applicable, meaning equally applicable to both domestic and imported goods. When there is a distinctly applicable measure, will there be a problem of breach of Article 34? Yes. How can we save this national act from being infringed of EU law? Again, Article 36 exceptions and proportionality. Now we came to indistinctly applicable measures. Normally, indistinctly applicable measures would always infringe Article 34, right? And could only be saved by Article 36 derogations and according to principle of proportionality. However, in cases, the Court of Justice also provides that when there exist mandatory requirements, that member state may be justified also and not to be considered as in breach of EU law. But the funniest thing is, nobody knows what is mandatory requirements. What is the phrase, the meaning of the phrase? In Turkish, mandatory requirements, zorunlu gereklilikler veya emredici gereklilikler. Mandatory requirements, or also referred as imperative requirements or overriding requirements in the public interests, are good reasons put forward by the member states to justify their conduct.